Hi everyone, my name is Beverly Allen. I've been practicing law in Tacoma for 10 years, and today I would like to talk to you about enforceable agreements. In other words, how do you get your agreement honored and enforced by the court in Pierce County? Now, this is part of the Pierce County Law Library's how-to video series. Pierce County Law Library has packets of information that may pertain to your situation, such as filing for divorce, filing for separation, filing a contested divorce, filing an uncontested divorce. Make sure you reach out to the law library for what you are trying to accomplish. But within each of those cases, and in fact, broadly in civil litigation, you may find yourself in a situation where you've already reached an agreement or you want to reach an agreement, you really want to settle the case, and in order to do that, you need to make sure that your agreement is enforceable. So, first, let's talk about some agreements that the court may want to weigh in on, even when you and the other party have an agreement. And that's two areas in particular. So for parenting plans, the court always has the ability to review the agreement and see whether or not the court thinks that agreement is in the children's best interest. Now, I will say that in 10 years of practice, I've only seen 2 out of dozens, if not hundreds, of divorce cases that I've touched, where the court has said, no, I'm not enforcing that parenting plan. And that situation usually comes up when the court does a criminal records search and finds something that is concerning to the court about either or both parents. And the way to tackle that is to have some kind of an acknowledgement within the parenting plan itself about whatever situation the court is likely to see. Additionally, you may want to consider restrictions that both you and the other person are comfortable with honoring. So I did have a case recently, it was a parenting plan case, where the person had a lot of mental health struggles and some alcoholism and substance abuse. That person agreed to evaluations, they agreed to treatment, and they agreed to supervised visits at first. So if the court sees something that is very concerning to the court may insist on those types of limitations and restrictions. So don't pretend that they're not there. You need to address them, and you need to address them in a way that protects the children's best interest. So the second area where the court might say, hey, I recognize you have an agreement, but I will not enforce this, is in the area of child support. So the court wants to make sure that there are sufficient resources in both parents' households to enter a child support order. Now, 9 times out of 10, the court is going to want you to either do the standard amount of child support or have a very good reason for a deviation from the standard amount. Keep in mind also, deviations from the standard amount are discretionary. The one thing that the court cannot do and will not do is mix child support agreements in with parenting time decisions. The court will tell you those are 2 separate determinations. The parenting plan is about the best interests of the child. The child support order is about sufficient resources in the child's home. By statute and case law, the court is prohibited from enforcing an agreement where, say, one parent has agreed not to see the child in exchange for not having to pay support. The court will not enforce those agreements. So make sure that you treat child support and parenting plans as separately. If you do need to reach agreements on child support, as long as there's sufficient resources in both parents' home, you can deviate. However, you need to follow the recognized standards for deviation, and keep in mind the amount you select is subject to review of the court. I had one scenario where the parents had agreed to a lowered child support amount because one parent was getting spousal support, or I think it might have also involved that other parent getting a bigger share of the community property. Well, in that case, the court was not comfortable with the first order of child support that parents had agreed on. They went out into the hallway, renegotiated. We came back with a slightly higher number. The court was comfortable with that. So different things can happen when it comes to deviation. Be prepared to explain the reason for deviation. And there are reasons that are set out in the order of child support itself that you can refer to. But this is discretionary. The court might send you back in the hallway to renegotiate. So that covers the areas where the court may not necessarily enforce your agreement and some of the traps and things to keep in mind. The one area where the court will agree to enforce your agreement in most cases is as concerning the division of property and debts. The reason I say most cases is the court will still insist that the agreements were voluntary and that there was no fraud or duress or attempt to hide the financial situation of one or both of the parties. But when it comes to financial agreements, it's basically a situation of a contract. What is the contract? What is the set of agreements that you are making? What is the set of agreements the other person is making? What are you getting out of the contract? What are they getting out of the contract? As long as the terms are fair, they're enforceable in the sense that both parties have already discussed it, have agreed to it, neither one is under duress, the court is most likely going to enforce those agreements. Even if it means, say, not dividing a community asset, such as a pension or some other piece of property, the court needs to award property in a just and a fair and equitable manner. That does not, however, necessarily mean a 50-50 split. So when you're coming up with property agreements, you have a lot of flexibility to deviate from that 50-50 split as long as the terms of the agreement are fair and they were voluntary, because it's possible for one of the spouses to value having a quick resolution of the case, even if it's not a 50-50 resolution of the case. So in most cases, your property agreements will be enforced. Now they should be signed, or they need to be signed by both parties. They should be clear as to the terms. They should not require a lot of interpretation. The court should know what you're agreeing on, and it should also be dated. So dated and signed with clear terms. Those can then be easily incorporated as exhibits to the final decree. Now, you may have some questions about how to reach agreements. I think most people generally want to reach agreements when they're in the middle of civil litigation, but they don't really know how to, or their emotions get in the way. Here is where I cannot stress this enough: get a mediator. Now, mediators come with a variety of backgrounds and trainings, qualifications. A mediator, by the way, does not necessarily need to be a lawyer, although it's a very, very good idea to get a mediator that is a lawyer, because then they can give a legal perspective as to your agreements, and they'll be familiar with the court system. So where do you find a mediator? Well, you can Google, you can find mediators in your area that are advertising themselves as such. You can also call the Center for Dialogue and Resolution in Pierce County or other dispute resolution centers if you're in other counties. Now, dispute resolution centers have an interesting history and function. They are actually, in part, they're usually subsidized by their counties to help with, say, small claims and to provide a resource for people to settle their disputes without having to go to trial. This frees up the trial judges to handle, say, criminal matters and matters where there simply isn't a resolution that's possible between the parties. So those centers for dispute resolution have a very clear training program. They're very good programs. They do, however, rely on volunteer mediators. So you can't necessarily pick your mediator, although you can usually specify whether you want your mediator to have a certain set of qualifications or experiences. Maybe you want someone with a military background. Maybe you want someone with a family law background. The center can take your request and try to match you with an appropriate mediator within their limits. And I've seen that happen before on my own cases that I've brought to the center. If you have an attorney or you're thinking about hiring your attorney, all attorneys will have a set of mediators that they like, that they rely on. They're usually other attorneys that have a good reputation for settling cases in the community. And by the way, the guidance as to mediation is applicable not only to family law cases, it will also work for, say, landlord-tenant disputes or contract disputes. These centers for dispute resolution handle a wide variety of cases, of civil cases, and I do recommend that you utilize these resources. Again, have the terms be clear, have them be dated, have them be signed, file them with the court. Now, it's important to note that they should be filed under a sealed financial source cover sheet if they contain sensitive financial information, or really any financial information at all. It really should be filed under seal. So with that, those are some tips that you can use to go ahead and mediate your cases, to reach resolutions that the court will enforce, and that will help you save the expense and stress of a trial and finalize your case so that you no longer have to worry about your looming trial date. I hope you can settle your cases appropriately. If you do have any questions about the process, please do go ahead and reach out to me, Beverly Allen, TacomaLegalCoach.com. I also have a Facebook page. I do Wednesday clinic appointments, and I also do coaching appointments. So I'm happy to answer any questions you have. The Pierce County Law Library is also a great resource for you, and I hope you use them in your case. Thank you.